cause of action is against the company. That is your argument.
No, there's nothing against the shareholder. Just see the pleading. Ultimately, even against the shareholder, there should be some pleading. Just see that pleading for a moment. Give me, just indulge me. I'm not asking you to open the paper. I've set it out here. Just let me read that notes. I've set out in extenso. I've reproduced it exactly. Just similar. The solitary pleadings in the plaint with regard to D17, plaint is from 38 to 107. It's a 90-page plaint. Para 18, the 15 to 19 and 21 to 28 defendants are shareholders of first defendant and are therefore beneficiaries of the trades done by first defendant on the plaintiff's exchange. Para 91, the plaintiff states that in view of the fraud and default committed by the defendants are jointly and severally liable to pay the outstanding amount with interest in respect of the said outstanding trades to the plaintiff. Para 111, the plaintiff therefore submits that this is an eminently fit case to secure the claim of plaintiff by attachment of all the assets of so-and-so defendants, since the liability of first defendant admitted by them runs into hundreds of crores of rupees, and the defendants are consistent with an intention to defeat and defraud the claim, which is manifestly evident by the act of restricting inspection of exchange designated warehouses. Prayer is this honorable court which is upon the decree and order directing first, third to 41st and 45th to 50th defendant to jointly and severally pay 937 crores. Now they relied before the High Court on this para 87. Just see overleaf. Para 87, the High Court just merely sets out the para. Just see para 87. It is pertinent to mention that from September 2009, when the first defendant commenced trading on plaintiff exchange, till August 2013, the management and the affairs of first defendant was run by the 6th and 7th defendant. In fact, 6th and 7th defendants were actively involved in the transactions entered into by first defendant on plaintiff exchange. The entire conspiracy to defraud the plaintiff exchange was conceived of and orchestrated by 6th and 7th defendants. It appears that the company is owned by 6th and or 7th defendants and other companies firm, which in turn were owned by individuals who are related or connected to 6th and 7th defendants, benefited from or participated in the fraud. The director shareholders of first to fourth defendants are either family members of 6th and 7th defendants and or people accustomed to acting on instruction. I'm not a director. My father
was a director.
He resigned in 2013. Suit is filed in 2021. 8 years after he resigns as a director. No government against my father.
The Roman 9, clause 9, Roman 9 of paragraph 87, that the shareholders are in collusion with the directors in respect of the fraud.
I'm not a shareholder.
You are a shareholder.
No, I'm sorry.
Paragraph 80.
It's a public limited company. I'm
a shareholder of the company. Your plea for dismissal is no dividends have been declared, so there is no.
I'm sorry, my lords. Please just see the law laid down by your lordship. This is this opens
law laid down by us is not to substitute a discretionary order.
No, this is not a discretionary order with respect. Not 711 lies even with regard to if the entire plane can be rejected against one defendant.
Advance arguments on 711.
Your lordship.
Your prayer is under order 1 rule 10.
I'm under 711.
711A. If you argue on 711, you are out of court.
Look, your lordship
made out. Simple.
Just see, I've set out the judgments also in this note. I'll tell you what. In Church of Christ, your lordships have categorically held that even with regard to an individual defendant, if the entire plaintiff can be rejected, 711 lies. Now there is no cause of action shown against me. Just making a bold statement.
Can entire plaintiff be rejected?
I'm sorry, Mr.
Can entire plaintiff be rejected when there is an allegation of fraud against?
Entire plaintiff has to be rejected. There's no allegation of fraud against me.
Doesn't matter.
Just
for that. What the remedy?
No, there has to be some basis.
Order 1 rule 10(2) will make your defendant a party, a misjoinder. So for that, it's the discretion of the judge to keep him as a proper party.
Look,
Simple.
I'm
It is not the necessary
saying
party is a
your
proper-
lordships have said that just by some artful pleading, look at the nature of the pleadings here. With this nature of pleading, every shareholder of every company will.
Please come to page 26, opening line of ground C.
Page 26, Milord.
Page 26, opening line of ground number C.
I'm sorry, just give me a moment, Milord. Grounds is the High Court failed to appreciate that in these circumstances, the petitioner only being a shareholder of, yes, I'm a shareholder of defendant number one. The description is only that I'm a shareholder, nothing else. Which means in every claim against a company, lakhs of shareholders can be roped in as defendants.
We agree with you. He is not a necessary party, but he can always be treated as a proper party.
There should some averment against a party. I can understand if there was an averment that apart from being a shareholder, I have in some manner done some act, any act, even one act. There's nothing here, not a whisper.
Where is your most respected father in these days?
I'm sorry, Milord.
Where is
Really?
your most respected father in these days? The whole country is eagerly waiting for red carpeting for him.
Look, only one thing, look, then let it be clarified that I can only be a proper party. Now, here, please see, if there's no absolute absence of any averment, not a single averment against a party, Milord.
Not a case where we will.
Please, Your Lordship.
Pay for the petitioner, my lord. Not
Yes, I to made.
yes. Not without hearing me on the first day, my lord. And then I've got I've got everything. Environmental clearance, consent to operate.
Approach the High Court.
No, tell your lordships, my lord. They've passed this order, and now the next date is April. And running, my lord. I know the stone crusher, the moment you hear it, everybody nowadays has a prejudice. But then, my lord, for 3 months, I'm a small entity. I opened in December.
April, so you can request the.
They've just, I had lots to say without hearing me. At least issue notice to me, my lord.
Therefore, if you have not been heard, please go and apply to the High Court. We will make some observation. You can approach the High Court.
My lord, may I just, a normal course, I should be.
Agreed by an interlocutory injunction order passed against him, passed against it by a division bench of the Uttarakhand High Court. Interlocutory order dated 7th January 2026 passed by a division bench of the Uttarakhand High Court. One of the grievances is that the order has been passed without even hearing the petitioner. So since the High Court is now opening after the summer winter break on 9th February 2026, first we say like this, it seems to us that the appropriate recourse for the petitioner would be to approach the High Court to appropriate applications for its impleadment as party respondent, semicolon, to seek vacation stroke modification of the interim order, and to bring on record the set of facts which the petitioner wishes to, set of facts on the basis which the petitioner claims that the song SAU and the song river is a non-perennial river.
Can I just, sorry.
Since the High Court is opening after winter break on 9th February 2026, we request the High Court to entertain these applications and pass appropriate orders by preponing the next date of hearing, by preponing the next date of hearing, with liberty of formation, the special petition disposed of.
Can I just say one thing? I don't interrupt a lot. My submission is that the relevant stretch of the Song River is non-perennial. That is the permission. Lordship said Song Rivers, that is not my contention. I have produced documents, the document which they gave, they gave is the reach of the Song River near Sankatiawala Kala is non-perennial. That is my contention. Lordship will say relevant stretch of the Song River. That is my contention. My contention, even when I file a reply, is not, nobody can say the Song River is perennial or non-perennial. The relevant stretch, it's a huge river. This stretch, which is what the permission is given, the joint inspection report is on record, in which
Your contention that you are away from the prohibited area of banks.
sorry, madam, sorry.
He's saying that the place where he's.
So ultimately, relevant stretch of the Song River. That's
Claims that and to non-perennial, that the site where the petitioner's stone crusher, you have stone crusher,
stone cross.
stone crusher is operational. The Song River at that near to that site is non-perennial.
Yes. I won't say anything for, I won't read. Lordship may read annexure P10, how this order came to be passed. I won't say anything.
Perennial and at one point, the river is either perennial or non-perennial.
Lordship may see annexure P10. I won't say anything. Lordship may just read it. It was supposed to be listed along with a writ petition against my rival the next day. From this matter suddenly gets detagged and get listed. I won't say anything further. P10, Lordship may kindly see. I won't say anything further.
Anyway, we have requested the High Court to prepone the date and hear you. Reply immediately and get a
No, the consequences are grave. On one day, without hearing a crusher stop, the small entity, the whole.
Mr. Vasan, these are environment issues. Precautionary principle guides the area.
With natural justice, my lord,
right?
without natural.
So a precautionary principle, when there is an RTI report, the website of the irrigation department shows it as a perennial stretch.
Which is why hearing us, and I've given a perspective. Anyway, Lordship has given me that liberty. I will.
Lost sight of facts.
I'll leave it. But. Oblige.
Actually, there are two matters before your lordship, 9 and 9.1. A similar matter, lordship, at page 212, lecture P6.
2013 का date में
Same order.
double 6 stroke 25.
My lords, we represent Ghaziabad Development Authority.
They are here.
Respondent 4 and respondent 3. The matter is coming out on 23rd of February.
Responder 4 only or responder?
4 in 9, we are 4, and in 9.1, we are 3 respondent.
Accept notice on behalf of the respondent. Counter affidavit can be filed before 23rd February 26.
Please,
That they will decide all.
please, oblige.
Then, there is a letter. Item 10, there is a letter circulated.
Please. Madam, this is the third time, my lord, the petitioner has been deported forcibly and illegally by the MP police and the RPF with the compliance with the RPF police. This is the third time this incident happened, my lord. He was not permitted to travel beyond his origination.
So what can we do?
My lord, this is a
How
violation of-
how do we examine these facts that you were dropped on the way?
Well, I have find the documents, my lord, that police himself given that letter saying that we are deporting you due to prevailing.
You don't have a place of protest in your state.
My lord, this is the case, my lord, where the.
No, you have a right.
Assured, my lord.
You see, we are not curtailing your right. You have a right to protest.
Yes, ma'am.
Peaceful protest.
My venue is not empty. It is the venue of Delhi.
Yes.
My venue is not empty.
Oh.
In the midway, we were.
Mr. Consul, council, have you applied to Delhi government authorities?
Yes, my lord, that letter I have annexed.
Yes.
There's no reply. Kindly see the letter which I annexed, 4th of October, I applied for letter. I gave a letter.
Letter
The
you gave, have you
number-
obtained permission?
Well, permission, no reply has come.
If no reply have come, that does not mean the permission has been granted.
Well, even Lordship presume that even no reply has come after the representation is given, that means there is no grievance for conducting dharma at Delhi.
If you are ready to listen to us, then you please appreciate.
Yes, ma'am.
There is an earmarked dedicated place for conducting peaceful protests.
Yes, my lord.
There you can have a political rally, you can have a non-political rally, you can have the farmers whom you are saying that you represent. The farmers can come there, they can protest for their demands, whatever. That's a part of the democratic process, no difficulty.
Yes, ma'am.
And for that, there is an earmarked place.
Yes, ma'am.
So first go to that competent authority, apply and obtain the permission.
When I gave a letter, my lord, letter, there is no reply.
The
When I even Lordship say that I have to apply before the competent authority, I gave a letter.
Yeah.
Even if the letter has to be given in person, I have to come to Delhi at least.
Yes.
But even half of the way, I was deported.
How have you, has he engaged you?
Pardon, my lord?
How has he engaged you?
My lord, he is from same place.
For the purpose of wakalatnama, for
No, my
purpose
lord,
of,
this is not the way, my lord. Kindly see this. There is a violation, a gross violation, 19(1)D and 19(1)A.
like to answer any question that we are asking you.
My lord, I am saying, my lord,
How did he come to sign your wakalatnama and papers?
my lord, as a council, I have to sign it, my lord, that I file a writ petition on his behalf.
You are filing without any wakalatnama.
No, Vakalatnama I filed.
Is there?
Yes, my lord.
So he came to sign your wakalatnama.
No, he sent it by post, my lord.
Okay. He sent it from there. Now he has authorized you. Why can't you apply?
My lord, it is duly notarized by the local notary public.
Very good. So he has sent it now. You are his authorized representative.
I send it, then there is no reply. That's why my submission.
Go and apply, please. Ask your clerk, you can apply online nowadays. You don't know to, even you are not required to go.
My lord, I'm not saying, my lord, because the question is that the representation has been given, no reply has come.
Well, I thank you. very much.
Thereafter-
Thank
Huh?
you. No case to interfere with you.
My lord, at least, my lord, kindly see, my lord, the last
No case to entertain this petition is made. Here you look, the petition is completely vague, evasive, and full of misdirected governments. The same cannot be entertained, dismissed. Role five. Petition are dismissed.
Earlier, my lord, I was given permission to go to the High Court, my lord. I applied for the High Court, I filed a writ petition. There also they said we have no jurisdiction to entertain because you were deported MP.
No, but your standard does not permit to go to High Court. You are not, your standard is not less than Supreme Court. So you are rightly come to
To High Court order also I annexed, my lord. After that,
Very good.
after dismissal of the writ petition, I went to the High Court.
All right,
I
thank you.
pleaded before the High Court.
Thank
High
you
Court
very
said,
much.
"We have no jurisdiction to stop anybody from MP, other than beyond jurisdiction of Madras." That
Thank
is the
you.
reason I come before Lord.
All right, thank you very much. Next. Item 12.
Lordship, I apologize in this matter. I'm sorry I couldn't circulate letter on time. Mr. Sibbal, who's leading me, he's unwell. So he asked me to make a request. I got information very late. I tried to circulate, but I had surpassed the time. So I'm just requesting 1 week adjournment, Lordship. He's not well. I spoke to him. So,
Your monopoly right is expiring when?
sorry, my lord.
May 2020.
Lordship, the patent will expire in May 2026. But there was an injunction till the time the division bench passed the order. So I'm just requesting for a week adjournment. There was an injunction throughout.
Next week. Next week.
Much obliged.
But if your lordship, so far as the lady is concerned, there is no allegation whatsoever. But please come to P4 at 61. That's the FIR. And if your lordships are kind enough just to see para 7 at page number 67. Apart from the invocation of 420, 406, etc. together, my lord, just come to para 7. Complainant, may I place it? May I place it?
Para 17 of
Para 7 of the FIR, not, it said FIR will begin at page number 61. I would like your lordship to see para 7.
yes.
The complainant ultimately advanced large sums totaling multiple millions of dollars, but as market conditions surged, accused persons began dealing, eventually ceasing delivery. So the whole issue is not, it's really a commercial transaction that we could not deliver because of change in market conditions. Others are surplusage and nothing against the lady, not. Nothing whatsoever against the second respondent in the entire FIR. Nothing incriminating. She's just been roped in because of relationship.
What is the stage of the investigation?
Lord, I must, in lordship,
Yes,
I
yes,
stated, Lord, charge sheet has been filed.
Let it be investigated.
No, Lord, may I just say this? My Lord, charge sheet has been filed in the interim while the matter was pending in the High Court. Charge sheet has been filed, but I have not been served a copy of it, Lord. Charge sheet has been filed, it barely makes out a civil transaction. I have not been served a copy yet because right now summons have not, process has not been issued. It's a case of not give or take of. Charge sheet was filed, Lord, but we don't have a copy. I can place that on record if your lordship permits.
Appear before the charge sheet has been filed, then go and,
I'm sorry, Lord?
if charge sheet has been filed, then go and seek your discharge as per law.
But I leave it to your lordship, but not purely a commercial matter where they say it's only a question of delay.
Commercial law depends upon that initially what were intention. If your intentions were right from the very beginning to dupe the investors, then you can't claim it a pure commercial transaction.
There was an MOU, and I must say this, for the second petitioner, there is, not this lady, there is nothing. May I just have a look at that for a moment?
Not a case that we can request.
Lord, may I just make a request, Lord? May I make a request then? Lord, the concern, I leave your lordship with one more concern. Lord, I was protected till a certain point of time. Kindly just see.
We know that is
Please,
only
please.
there. That will be length here. You will be released on bail.
Get. And we'll take our remedies, Lord.
Absolutely.
Yes.
The petitioners are aggrieved by the judgment dated 22nd December 2025, passed by the High Court at Calcutta in Brecker Port Blair bench. By their revision petition seeking question of FIR number 34/2025, dated 13 July 2025, registered at Cyber Crime Police Station, South Andaman, has been dismissed. We have heard Sri Siddharth Luthra and our senior counsel representing the petition and report and view the report. It is clearly admitted that after investigation charge sheet has been filed. That being so, we are not inclined to entertain this petition. The petitioners, if so advised, may move an application for their discharge. Such an application shall be considered by the trial magistrate in accordance with the law. Next paragraph. We review to enable the petitioners to join the court proceedings, it is directed that the arrest of the petitioner shall remain stayed. Share number first petitioner company. It is directed that the arrest of petitioner's number. Petitioner is a company, Mr.
Sorry, not,
Petitioner is a company.
not number 2. Second
Number-
petitioner. Number 2, Latifa Banu.
Petitioner's number in
And there are second, 3 matters, not the other individual petitioner. In matter
petitioners
2,
in SLP criminal number 1790/2026 and SLP criminal number 12.
we'll give the name.
825/2026 also shall remain stayed, subject to their surrendering before the trial court within 1 week and finishing adequate bail bond, full satisfaction of the trial court. So the learned magistrate shall be at liberty to impose such other conditions as may be deemed appropriate, which were on as may be deemed appropriate.
But my lord, we make it 2 weeks is all I'm requesting instead of 1 week, because one of them is based here. Flights are sometimes a little problematic. 2
Right, 2 weeks.
weeks. And one request for discharge will not be influenced by the observations, because there are some observations on merits.
Nothing, Mr.
My lord, there are some observations on merit, menstrual, etc.
Thank you very much. Thank you.
Grateful.
Please, my lord,
Of sentence. Yes, Mr.
please. My lord, the first round, my lord, the constables came and the ground was that they were simply following the directions of their superiors. Now, my lord, here, they are the advocates and the advocate was throughout present during the commission of the offense. The High Court records that CCTV is not clear and therefore his presence is disputed, whereas, my lord, there was a test identification parade in presence of an executive magistrate and thereafter followed by, my lord, his identification in the court. And, my lord, two, my lord, the High Court records the phone which was found and which was used by this person, my lord. That phone was lost by somebody 6 months back. That's also wrong because it is recovered from him at the time of arrest. Please have a look, my lord, at page. And please see, my lord, he was described as an unidentified person and it was told in the first complaint that once I see him, I can identify. Therefore, a test identification parade was conducted, my lord. Now, please have a look at para 14, my lord. Page 15.
Test identification parade, because the FIR was delayed, was after 4 months of the incident.
My lord, there was an inquiry prior to that. There was an inquiry, my lord. And please see, my lord.
Lawyer's presence was not spelled out in the FIR.
No, my lord, please see. I'll just.
When he goes to the Home Minister and then the FIR gets registered in April.
It was.
We understand that.
Please,
there
please.
are some influence, etc. But still then the fact of delay.
Please.
We have to examine the identification in light of the fact of delay between the parties. And admittedly, this person was advising some of your partner.
No, my lord, he was never, my lord. The High Court records that his father was once upon a time an advocate.
Your father was the lawyer of your partner who is accused.
But my lord, he never appeared for me. Please see, therefore I am pointing out, please see para page 15, my lord.
Yes.
Para 14, my lords, may have a look.
Necessary, the point is that in a case where the
My lord, in the first round, my lord, when I pointed out that this may not be treated as a precedent, my lords have clarified in the order that in the peculiar facts and circumstances of the case, where there were constables simply, my lord, following the directions of their superiors, my lord. Here, my lord, please see the police officers are, my lord, IPS officers, my lord. The police officers are a former MLA is before my lords, my lord.
question is, it's a pendency of appeal. But the appeal will be heard, all these.
4 months, 364A, life imprisonment. The evidence is on record. The findings are flawed.
High Court has made a fine distinction between the conspirators.
Therefore,
the superintendent of police has not been granted suspension.
Lord,
Your partner has not been granted suspension. It's the lawyer, the constable, and the former MLA who have been granted suspension.
but there should be
There's
the
a
findings
clarity
can't
in
be,
the
my lord, contrary while
of
granting
culpability.
suspension, my lord, with all due respect. The findings can't be contrary to the record, my lord. Please see, therefore I am pointing out, kindly have 2 pages, my lord. para 14 at page, my lord, 15. Kindly have a look, my lord.
Yes.
It says, my lord, the applicant was throughout remain present when the act of ransom and kidnapping being made by the police officials. Hence facts remains that the CCTV footage relied upon the prosecution seems to be not as much as clear. My lord, I was there, I identified. And two, my lord, now please see the second finding.
Mr. clarified that this observation had nothing, will have no bearing on merits. But the point is that once bail has been granted, why?
Lord, yes, I can understand, but this is an offense, my lord. Please appreciate a police officer is posted, my lord, 400 kilometers away. He comes to Gandhinagar from Amreli, and then he abducts. Then there is a transfer of Bitcoin where this MLA is involved. The advocate is present throughout the incident, my lord. Even prior to that, in the conspiracy, my lord. In the conspiracy, right from 7th of February till 11th of February, they were in constant touch. The person who was released, that is Kirit Paladia, and my lord, this MLA and these lawyers were in constant touch, my lord, on phone. Those are CDRs on record. There were meetings in the circuit house, the government circuit house, my lord. That is all, that register is on record.
Question of connecting this entire evidence to establish that there was a meeting of mind or that there was
There is no.
a preconceived conspiracy. All these are matter of trial. Because
Therefore, my lord, there was
substantial evidence.
But, my lord, if the findings, my lord, are prima facie in contradiction to the evidence on record, just kindly have a look, my lord, what the learned judge records, my lord. Only one thing. Here, my lord, the High Court records that, kindly see page 16, my lord. What the High Court has recorded. That the mobile number 816, the last digit, claimed to have lost 6 months back. And then please see page 443. It says there is a finding that further the mobile number so and so recovered from the accused Ketan as per the deposition of so and so. So there was a recovery. The High Court records that it got lost 6 months back. My lord, the findings are prima facie, my lord, in contradiction to the evidence on record. I can understand suspension, but please see, my lord. So at least, my lord,
assuming it's an erroneous order, even then we should not intervene. Unless we find a complete pervert order going completely beyond jurisdiction, where the High Court.
My lord, this is prima facie in my respectful submission, my lord. Once the High Court records a finding which is contrary to the record, my lord, then what more perversity is required, my lord, with all due respect. And please see, and two unidentified person, my lord. The High Court records he has not named. I was not actually knowing him. He came in Elantra car, my lord. That Elantra car he borrowed. That witness evidence is there.
The impugned order pertains to suspension of sentence and grant of bail during pendency of criminal appeal. We are not inclined to fulfill with the same. Especially.
And this may not be treated as precedent, my lord. Now the police officers are in line. At least my lords may say that, my lord. They may not get the benefit of parity, my lord. If at all my lords are, my lord, not intervening, my lord, because of the rules, my lord.
It goes without saying that such a frame, if made by the who accused who are police officials, shall be dealt with by the High Court as per their own right.
Please.
High Court has already rejected.
14 and 15, my lord. 15 is. No, the other police officers have not come. Only one, and he has withdrawn. My lord, only one. Only one. That is Kirit Paladia. He is not a police officer.
police.
No, my lord, superintendent of police, his application is.
No, that has been turned down.
No, it is
The
only
High Court made
the
a.
police inspector, my lord, not the superintendent of police.
The superior police officer, the constable's bail were granted.
Constables were
The superior
granted.
police officer's bail has been turned down by the High Court.
No, only the
One
police
of them.
inspector, my lord, one of them.
Inspector.
The SP,
SP is two.
yes, my lord. Now SP is waiting for
The
the house.
inspector is down.
With the addition of this line, they will be taken care of.
Please, my lord, we are grateful.
Came out of getting, came out.
Please, my lord. My lord, this is a case where petitioner is seeking his right of hearing on the bail application. My lord, what is happening that bail applications are being filed by the litigants, and that is keep on adjourning without taking on the roster because of the heavy roster or any other reason. We have the compilation of इधर से दे दीजिए एक बार ये दें दे दो उधर My lord, we have the compilation of various cases where such type of practice is being done, my lord. Please, my lord, I have the list. I have prepared on my own. It is not the list of compilation of all such type of cases. But suppose the case is at serial number 3.
Sir, report.
So. In this especially the High Court for grant of regular bail. Petitioner has told the High Court for grant of regular bail in a case registered under section 115, 190, 191 in bracket 3, 324 in bracket 5, and 351 in bracket 3 of the BNS 2023. The petitioner was arrested in that case on 11th August 2025. His bail application to approve the High Court for grant of bail and this application came up before the High Court for hearing on 8th December 2025. It was adjourned to 20th February 2026. That is for a period of more than 2 months. The petitioner then applied for preponement provide impugned order dated 22nd December 25. His bail has been declined on the ground that the bail application of his co-accused has already been dismissed. Next paragraph. During the course of hearing and on a query by this court, Mamata and senior counsel for the petitioner submits that there are numerous bail applications pending in the High Court of Punjab and Haryana at Chandigarh. Where matters are urgent, where the dates are being given months after, and as such the bail applications are not being decided for a long period. On a further query and on an illustrative basis, he has submitted a chart of some of the bail applications which are pending since October 2025 and are currently urgent to since May 2025
Right.
and are currently urgent to different dates in the month of March 2026. For the state,
Yes, Your Worship, I am appearing for state.
it's not your fault. Maybe.
Yes, yes.
Your fault may be that because you might be taking date or you might not be producing the record. But this is not the way the High Court should deal with bail application. If you don't want to grant bail, you reject it. For 6 months, for 1 year, you don't decide the bail application.
My lord, I have given the suggested measures also, where the state is seeking time for filing status report and on any other, there are various reasons for which the bail applications are being pending. There can be mechanism, my lord, because 7 days time is always given in regular bail in High Court. Within that period, they should file the status report so that it cannot be adjourned. Because once adjourned, then it goes after 3 months.
You had introduced a system there that when you file the bail, you don't know now, you file the bail application, you will give an advance copy in the AG office, and when after a gap of 1 day, the bail will be listed and the IO will remain present in court.
Earlier it was being listed, but now.
Of course, now with the hybrid system, the IO can appear even online.
Yes.
But the bail application could be decided the very third day.
Yes, but now it is listed after 7 days. And even within 7 days, no reply, no status report, no.
And that's why when we ask for the disposal, only these bail application disposal is shown. The regular matters are still pending there. All 1985, 86 RSAs of criminal appeals, everything is pending.
It directly affects the liberty of the litigant.
Next paragraph. सारे सर्विसेज से जाते हैं उन्होंने लाइफ में प्रॉब्लम At page 22, you can't blame the judge on a request made by counsel of the by petitioner.
What is happening in some of the case is not being taken up. Thereafter, the counsel check the list. Then what is that on the request of the counsel adjourn and status report is awaited. There are also some of the cases. I have given 7, 8 suggestions, my lord, how it can be mechanized or improved, madam.
The biggest problem is that there is no orientation, there is no training system, there is no sensitization program of, after all, they are high court judges, they must themselves realize it.
My lord, I have given the
क्या लिखा है भाई? हाँ. ROPs have also been produced in order to show that how the matters are being adjourned repeatedly, how the bail matters are being adjourned repeatedly. Next paragraph. All that we wish to observe at this stage is that we are extremely disappointed to see as how the prayers pertaining to the liberty of individuals are being dealt with. It may be true that the dockets are very heavy. There are other matters which do require prioritization. Among the miscellaneous matters, nothing can be more important than the decision of the fate of, nothing can be more important than deciding the fate of the prayer, grant or refuse bail. Next paragraph. We expect Honorable Chief Justice of the High Courts to take some remedial measures. इससे पहले कराया डर ऊपर almost shocking. Don't say shocking, okay? It is equally disturbing to know that in the Patna High Court, bail applications are not listed even for preliminary hearing for months. And more than 14,000-15,000 matches are pending. One of us, vividly recollect various matters coming to this court only for seeking directions only for listing of their bail applications before Patna High Court. We have no reason, next paragraph, we have no reason to doubt that Honorable the Chief Justice of the High Courts are cognizant of such prevailing conditions where the High Courts unfortunately are not even able to decide bail applications on time, in a reasonable time. This is happening despite the fact that on occasions, this court has indicated timeline for adjudication of such type of matters where there is an inbuilt urgency, keeping in view the very nature of a relief sought. It seems that those orders passed by this court have not been able to bring the desired sensitivity as a result of which, due to which the high courts have apparently not evolved any robust mechanism for time-bound adjudication of the bail matters. Next paragraph. We are conscious of the fact that listing and prioritization of the matters for the purpose of listing is the exclusive prerogative of Chief Justice of the High Courts, they being master of their respective rosters. So, however, if the people are languishing in jail, semicolon, their bail applications are not being even heard, and they are completely in and there is a complete uncertainty when will they be able to know the fate of their applications. It seems that this court is under a bounden duty to lay down certain mandatory guidelines. However, before we do so, we direct the Registrar Generals of all the High Courts to send complete details of the anticipatory and regular bail applications pending in the respective high courts, along with the date of filing, a date of decision, or the next date of hearing. All the bail applications, such details shall be furnished for the time being in the respect of all the bail applications which came to be filed on or after 1st January 25, filed on or after 1st January 2025. So, applications filed prior to 1st January 2025 are also pending. जहाँ पे है ना anticipatory bail application then स्टॉक करना applications for suspension of sentence. Three categories. However, if such applications filed prior to 1st January 2025 are also pending, comma, details thereof shall also be furnished. As per the adverting to the case in hand, we find that the bail application filed by this petitioner is coming for hearing on 20th February 2026. We request the Honorable Judge to decide the same on merits, either on the date fixed or prior thereto, if an application or prior thereto, provided that the petitioner seeks preponement of date. Next paragraph. Within 4 weeks, the matter for further consideration on so and so day. All the state governments are directed fully cooperate the high courts for early and time-bound adjudication of the bail applications, stroke prayer for suspension of sentence. The High Court shall sentence to the states should be ready with the relevant information as and when the bail application is listed for hearing, provided that a copy thereof has been handed over to has been submitted in the Office of Advocate General and or the public prosecutor at least 3 days in advance. At least 3 days in advance. Such like matters, the investigating officers or the authorized officer can be permitted to appear online also. The Registrar Generals of the High Courts are further directed to circulate disorder amongst the honorable judges of the High Courts with our fervent appeal to them for expeditious disposal of the pending bail applications. next paragraph. The Honorable Chief Justice are also requested to revisit their roster stroke listing arrangements, and wherever they find that there is a mismatch between the total pendency and the bench allocated for deciding such matters, comma, they may consider the desirability of listing the bail matters before. They may expand the roster for listing of the bail matters. Post the matter on so and so date.
May I make one more submission, my lord? My lord, in cases of suspension of sentence, sometime what is happening that custody is more than 7, 8 or 10 years. Suspension of sentence bail application either pending or disposed of by listing the appeal. But appeals are also not being heard. And 7 years custody, 10 years custody after conviction of total, my lord may also call the report. The appeals in which custody is almost.
Said Dr. Pankaj that there are the system that has its own difficulty. If you start taking your only criminal appeal, the matrimonial appeal, the matrimonial cases, the other admission matters, academic matters, those get delayed. Some balancing has to be done.
There is no doubt that that is heavy roster, but 10 years custody is something.
No, undoubtedly we don't, we strongly disapprove rather if there is custody of more than 10 years, even normally in a case of life sentence, barring a few cases where death sentence is there or the crime is so heinous that life imprisonment means that he has to spend 40 years or so. In such cases, there is no question of granting bail. But then you pass an order, dismiss it, matter ends. Somebody would have lied, if they have a right to go and appeal, let them come. But keeping pending is what is bothering us. You pass an order, that is prerogative of the judge. Whatever order they want, they let them pass. Right, let us see.
Items 36, 37 are those Bengal SRs. In the sequence, it was supposed to come after 16. So, is that being taken up?
We'll take up to.
Because sequence was issued this morning. It said it's after item 16. Items 36 and 37.
After this,
fresh matters.
1 or 2 fresh matters are left.
Yes.
After that,
These are fresh. 36, 37 are fresh matters. Bengal SIR.
those are will take with us.
I'm great.
Just a minute, only 2 matters are left.
Very well.
I'm great.
Yes, item 40.
Yes, my lord, I appear for the petition.
You can argue from there now.
Only difficulty is, my lords, the elections are slated to, my lords, on Friday. My lords, my objection was dismissed only on 22nd. Also on 23rd, immediately I have moved the High Court.
Pending.
Immediately before the High Court, I have moved, my lords, the very next day.
They want to oust your opponent at the stage of nomination itself.
No.
You don't want to face in the election.
No, my lords, the only difficulty is that, my lords, I moved the High Court immediately on the next day. My lords, no hearing has been given.
If you win the election, then he is out by itself.
That is it. May I only make one request, my lords?
23rd. Options open.
Yeah. I'll withdraw this petition. But only request is that this objection I may be allowed to raise at an appropriate stage. Because the difficulty I'll face otherwise is that the order of the returning officer which is against me.
Counsel for the petitioner seeks and permit to withdraw this petition with the liberty to raise all the to raise all the contentions at an appropriate stage. Order to court.
Very well. I'm highly.
Item 41.
Lordship, almost more than 90% encroachment has been removed from the government and forest land, Lordship. This fact is already acknowledged by the respondent number 2 to 5, Lordship. May I read, Lordship, annexure P5, Lordship? Page number 36, Lordship.
But why not remaining 10%?
Actually, Lordship, but there is a one beam, Lordship.
My lords, I am appearing for R1, my lords, for Miss Chandil, my lords. My lords, my only two summations, my lords. The first is, my lords, in the month of May,
If that pillar of the house,
my lords,
beam,
my lords,
normally they don't construct pillar in Himachal,
my lords,
but that beam or whatever support to the roof,
my lords,
that is coming in the government land.
my lords.
And if that is removed, the entire house will fall down.
My lords, they were new while they were constructing, my lords.
Like they knew.
Who is he, Lordship?
They were new the consequences of my lords. Still they constructed, my lords.
Who is he, Lordship? In which capacity is he appearing?
My lords, again, in the month of January, my lords, the petitioner again encroached the government land, my lords.
That we will.
They are using
₹40,000 crores. And the investigation is ongoing. This is, of course, my lord, bank's public money.
40,000 crore. But the point is, there are 2-3 disturbing things. One is that, are you presenting CBI also?
Yes, yes, my lord. CBI, ED both.
Now, CBI says that on the basis of the complaint received from one bank, FIR is registered, matter is being investigated. Meanwhile, from other financial institutions also, complaints have been received. Now they say we want to register separate FIR.
We do. No, my lord, what we have done is, I have taken specific instructions on that. The first FIR came from the State Bank of India. Thereafter, my lord, other banks also intimated us about their, my lord, alleged siphoning, etc. That is also now included, and it's a part of, my lord, the investigation. Because we cannot have separate FIR.
These complaints, are these not, will these not amount to constituting a separate independent offence? Nature of the offence may be same.
Yes, my lord.
Nature of the offence may be same, but in terms of
transaction as, my lord, used
the
in the judgment
complaint is different, the time of transaction might be different, the manner of transaction also might be different. Ultimately, so therefore that will constitute an independent offence. Why are they not registering those?
Lord, that can be done. We will examine. Possibly, my lord, there was a consortium lending. If that is so, then perhaps, my lord, separate.
In the case of consortium and the lead bank has made a complaint, understandable. That will, provided that the lead bank says it is for and on behalf of all the banks.
No, my lord, the lead bank says only for it. That's correct. No, we will examine that, and we are not averse to registering separate offences if these are separate, severable transactions. There is no difficulty.
Actually, my lord, in this case, this FIR has been registered in 2025. The Bank of Baroda's audit report came in 2020, in which they had detailed the manner in which the funds have been siphoned out, etc. So the bank, unfortunately, did not for 5 years, did not lodge this complaint with the CBI. Only in 2025, they seem to have lodged that complaint. And till today, my lord, only after your lordship issued notice, they have effected the first arrest in the matter day before yesterday. Till today, my lord, in a bank fraud of this kind, this is the largest corporate fraud in this country.
Now that it has been brought to our notice, and we will continue to monitor it.
Yes.
And we will ask them to file status report.
That's what
That's what we
because the cross-references
in my they make a submission, but I appear for R5. There are, my lord, 5 FIRs by CBI. representing my lord a large number of banks.
Earlier, I
There are 3 ED my lord PCIRs based on that. There is 12,000 crores worth of attachments, my lord. There are, my lord, more than 100 summons.
The first arrest in the matter day before yesterday.
It's not
Till today, my lord, in a bank fraud of this kind, this is the largest corporate fraud in this country.
Filed by ED, set out, my lord, all this what I'm saying. And so what they are doing, and they say that, my lord,
That's what,
etc., etc. That's for them.
That's what we want.
As per the law, I had a proposal. I appear for R5. I am not, my lord, there are, my lord, 5, whatever, my lord, FIRs by CBI. I have a representing, my lord, a large number of banks. There are 3 CD, my lord, PCIRs based on that. They say it is siphoning. There is 12,000 crores whatever attachments. Business losses. There are, my lord, more than 100 summons.
The first arrest in the matter day before yesterday. Till today, my lord, in a bank fraud of this kind, this is the largest corporate fraud in this country.
Filed by ED. That's what I'm saying. As per the law, and they say that, my lord,
That's what
etc., etc. That's what we want. As per the law, I had a proposal. I appear for R5. I am not, my lord, there are, my lord, 5.
Lord, I have something.
To my lord, the Chief Justice, my lord, taking a call on the government.
Lord, only a minute, my lord. We, the banks, Lord, conducted a forensic audit by an outside forensic auditor, my lord. And the forensic auditor has said that there is siphoning and other things, my lord. Lord, we may perhaps not be able to, my lord, compound these offences, my lord, even if there is a readiness to pay.
Mr. Solicitor, in spite of what you are submitting, see paragraph 27 of the CBI report. You are dwelling on 17 capital A again. If the forensic auditor says that there was a breach not of loan terms but of collusion, then what is the question of stopping the registration of RCs in view of taking sanction? These are declarations. Please examine.
I will answer my lord's question. I have put it to the government, my lord, to the CBI.
23
Yes, your lordship's question is very pertinent. My lord, the public officials are also under the investigation. They are also under investigation. Number 2, the respondent number 5 and is possibly respondent number 5, the individual, filed suits in Bombay High Court, and there is, my lord, an injunction granted not to act upon the forensic audit report, my lord, on the ground that the person who signed the forensic audit report is not a member of the Institute of Chartered Accountants. I am not going into it. Banks have filed an appeal. Appeal is heard and the judgment is reserved. Well, I appeared for the bank as well.
I appeared on, that's a completely different issue.
Different thing, my lord.
We are entitled to say a report is good or bad.
I am not on the merits.
That matter has been argued, so we'll wait for the.
Yes.
Your judgment will come soon in a week or 10 days.
An injunction has to be subject to 41 of the Specific Relief Act. You can't get an injunction on registration of
Injunction perhaps may not apply even to an independent
We are not arguing that case here, my lord. Question is, there is a report which, my lord, declares me as a fraud. Report is issued by a person who is incompetent to do so. So I am questioning that. That's all.
There are 2 things.
Yes.
If there is an intention to siphon the public funds from X to Y to Z from the very beginning, and if that has actually happened, then probably the solicitor is right in saying that this kind of offense can't be merely because you are willing to pay.
Agreed.
That cannot amount to condoning.
Absolutely right. But my lord, it is my case. There was never any intention. We have done business for 40 years.
That is what precisely has to be seen on the basis of the investigation.
No problem.
Now, as my brother has pointed out, we will not allow this kind of impediment that 17A sanction this and that. If the bank officers or some officers
they are also under investigation, I am instructed.
If they are not involved, it's fine. But if they are involved, then they must
they are in collusion or in any way accomplice. authorized, then they are also under the investigation.
So, I am not opposing anything. I have come, my lord, with a proactive stance. I have cooperated. I will cooperate. Whatever is your lordship will direct, we have.
What you are suggesting, Mr. Gopi, that can only be probably from your side. It has come. Provided that after thorough investigation, someone says that it was a case where
which is a snapshot. Now the number of days
That's
left
right.
for the final publication.
No problem. Misappropriation, misapplication or something. But it's a deliberate siphoning of.
It can happen. It can happen, my lord. People do go bankrupt. It's not that every man, my lord, has taken money and run away.
I just want
Even if we ignore the audit report of the bank,
2026.
the ED in their counter affidavit is saying that they have found evidence of forged bank guarantees being given by them. They have
Therefore, I said it may not be possible to
forged bank
compound that
guarantees
offense for
filtering out
somebody.
all these tax havens. At least 26,000 crores has been siphoned out to these tax havens like Mauritius, etc. Not a single penny has been coughed up. They have declared bankruptcy in all their companies. 1,78,000 crores of outstanding dues in these companies. 1,78,000. The only amount recovered in bankruptcy proceedings is 15,000 out of 1,78,000. Most of the money has been siphoned out. That gentleman, my lord, who owns all these companies, he has not been arrested till date. Till date, my lord, the main person, the kingpin of this whole scam has not been arrested. Only they arrested one officer of this company 2 days ago, day before yesterday. Only because of this matter coming up.
Number of micro.
No, not because of that. We are before your lordships and we will have to ensure that your lordships' conscience is satisfied that the investigation is impartial and going in the right way.
Under their manual, it's a very, very limited role which they have on election day.
Our order has
Not for activities which have been
but we
deployed
expect
right
that your
which has been
agencies
given to them at this stage. Number of approved documents rejected after hearing
we would like to have status
now, this is one of our grievances.
in 4 weeks.
Residence certificates, the family registers, the domicile certificates, Aadhaar card, PC certificates, and land certificates.
It is.
This is not correct. This is absolutely not correct. There is banding figures like this. It's absolutely incorrect.
I'm
appearing for respondent number 4, which is the group of
companies.
Here, Manoj, I might just mention that the service, the impression carried, I think last time when your lordship passed the order, was that service was effected and we were not appearing. In fact, we have just they went to etc. But anyway, now we are on.
That's true.
I'll be grateful for that. The second point which I want to mention, because a large number of figures have been bandied about, that in the last 5 years, 2 of the companies, Reliance Infrastructure and Reliance Power, have paid back a total of 20,000 crores of rupees. 20,000 crores of rupees. Now, this is a very, very important.
The amount is 1,78,000.
What I'm trying to get see that those figures are not correct. What we're trying to project over here is that when a party has repaid 20,000 and these 2 companies are now virtually debt free, I mean there will be obviously some requirement for working capital, etc. But it's over something like 50 lakh shareholders, small investors are there as far as these 2 companies are concerned on the aggregate. So this is, my lords, obviously a group which repays the amount. Now we will see there, as your lordships may have seen from the, we don't have the advantage of the report, but we do have the enforcement directorate affidavit which has been taken. Where there's a series, the affidavit says that there's a series of steps and measures which have been taken in the last 6 months. So there's a relentless, my lords, effort. We are trying to ensure that the payments are made, and there is no question, my lords, as far as the suggestion of siphoning, etc.
Just one company.
Anyway,
one aspect.
and therefore, my lords, I think the suggestion which was made by Mr. Rosti is a valuable one. Most of the, and you see the enforcement directorate affidavit also, that's all that we have. They have talked about public funds, etc., being siphoned away or being removed. Now that doesn't seem to be the correct impression, which the enforcement directorate, but they are entitled to their view. So therefore, if there is some solution which can be found to bring this out, at least it reduces the issue, because that's the primary purpose of.
Let us see that.
Let me respond, my lord, on two aspects, my lord. Number one, lord, in the forensic audit report, lord, it has come out that in some cases the money is taken as a loan from one bank to repay the another bank. That may be, my lord, I will have to check up, my lord, that may be the way in which, my lord, this is repaid. Second, lord, this suggestion placed before your lordships may not be utilized in other forums that now Supreme Court is considering constituting a committee which will go into what is payable and how to pay. Because there are suits and petitions pending.
We are not constituting any committee.
Yes.
We are still expecting, and we are hopeful that CBI and ED will do their job. They know how to do it. We are expecting them to coordinate. If at all we find that there is some kind of delay in their part,
of war. Bengali language doesn't have a war.
sir, instead of my brother being addressed as Vipul, they will address the Vipul.
On this aspect, may I just, sorry.
But my name, there will be no mistake, because it's a basically Bengali name.
Sir, it may be, sir. Sorry, sir.
With your
Because
board
you-
permission, could we just have an insight over here? Yes, please.
5 minutes.
If you allow me.
So, go ahead.
So my understanding was that mere spelling mistakes notices are not being issued.
Are being sent.
But now that this chart is being issued, is shown to your lordship just now, I need to get an instruction. Your lordship may have it tomorrow or day after, whenever I can. Yes.
The executive head of the state is also very much present. If the state government provides a team of officials who are well conversant in Bangla and who are well conversant with the local dialect,
Yeah.
and they scrutinize these, just scan through these and tell the commission that this is here only a local dialect mistake.
Yes.
And not any identity mistake.
Yes.
That will help them.
No, it will help them, but it's apparent.
Oh, Johnny.
Actually,
Apparent in some of the cases on illustrative basis it may be, but it will become humanly impossible for you or for us to go through and to.
May I explain you, sir?
Give me time till tomorrow, day after, lords, then I can get back.
May I explain you, sir? Because I belongs to that state. I am a.
Can there be any doubt, Madam?
No, sir. No, sir. I am very grateful, sir, because of your kindness. My humble regards to my Honorable Chief Justice, Mr. Babchan, Mr. Panchali also, Panchali ji also. Thank you very much. And my humble regards to Mr. Dwivedi and others, my opponent lawyers also. Sir, the problem is, always our lawyers fight for the case and they're fighting from the beginning. We are also. But sir, when everything is finished, when we are not getting justice, when justice is crying behind the door, I quote Rabindranath Tagore, then we thought that we are not getting justice anywhere. So many times I have written 6 letters to Election Commission, including all the details, but no reply, sir. I'm a bonded laborer, sir. Maybe I prefer that. I'm a very less important person. I prefer that. Sir, I'm from a common family, but I'm not fighting for my party.
Madam Mamata, sorry for interruption. The state of West Bengal, in its own right, has filed a petition, right? Today, of course, you are also coming in your individual capacity, but state of West Bengal, in its own right, there is nothing wrong in that. State of West Bengal has also filed a petition.
State of West Bengal has not.
One of the best concerns in the Supreme Court, fortunately, are there to not only are to represent the case of the state. Mr. Sibbal appeared on that day. Today also, incidentally, Mr. Diwan is there. Then in the other matter, Mr. Gopal is there. The best of the team, the legal team in the Supreme Court is there to assist the matter. Mr. Sibbal goes slightly relevant.
Sir, if you allow me 5 minutes only.
Now he is there.
Only 5 minutes only.
We will give you not 5, we will give you 15 minutes. We are only pointing out that on 19th, very eloquently he explained the procedural difficulties which the state was experiencing and where the state had some genuine apprehension for exclusion of the bona fide citizens of Bengal, the residents of West Bengal who are citizens of India. So therefore, those directions, the directions which Mr. Diwan just read out were issued. Today, in your petition, some additional issues are being flagged. Absolutely right. Issues are being flagged. Every problem has a solution. So we must look toward the solution in order to ensure that no innocent citizen is left out. This SIR is based upon only on 3 grounds. Dead persons are excluded, no difficulty, neither you will want, nor anybody will plead for the dead persons. Similarly, the persons who are disqualified to remain for any reason, somebody is convicted, whatever may be any ground in the law, you will not plead their case. Similarly, those migrants, the word is migrants, migrants is also one of the ground. Those who have left West Bengal, even you will not plead there. But the genuine persons must remain there. Now, among the genuine persons, one of the ground, as Mr. Diwan has today flagged, and rather we are thankful to you also, that in your petition now this issue has been raised, that because of the local dialect or because the manner which the Bangla people will proudly pronounce a name or it, because of that, and this all because nowadays AI assisted computerization, that you are speaking Datta and they are recording something else. If this kind of things are happening, we will find out a solution. They will have to find out. They can't. They will not like to run away from that responsibility. That by virtue of this kind of mistake, the genuine and bona fide person must not be excluded.
Sir, what happens now?
Only one.
Sir, what happens now?
Permitted before they could open millets. In so far the Election Commission of India is concerned, I represent. In that matter, so far we have not been served with any pleadings. We are clueless what their grievance is. If it's been there, if it's served on us, a week's time given, we'll get all instructions, we'll place it with your lordships, and look forward to any genuine difficulty to be redressed.
Week's time will be too late.
So be it, millets, let it be on Monday. Let it be on Monday.
Sir,
because millets were clueless what the grievance is.
Sir, this is not.
Item 21
Please allow me, sir.
The reply in 21.
You are right in saying that you have not been even given copy because the matter is coming first time for hearing.
Indeed.
The only thing is that since all this entire procedure has a timeline, at that timeline, we had extended on 19th January for another 10 days.
True, minutes.
But that 10 days time is also now, because they rightly pointed out by Mr. Diwan that out of that extended period, only 10 days are left. 4 days are left. After those 4 days, only 11 days are left. So this being a timeline, we can't grant you the luxury of 1 week notice.
Minutes on Monday, so that sir will come to know what the grievance is and will suggest or place with your lordships the remedial measures.
Please allow me to finish my point, please.
In principle,
yes,
if it is happening that Roy, Datto, Ganguly, Upadhyay, anyone like this, by virtue of the local dialect, if the name is being spelled out slightly different than what the accurate words might be, somebody can say.
Precisely.
In a given case, we do not know how Tagore is also defined. Maybe somebody put the E in the last, somebody may not be putting E. But that does not mean Tagore is not Tagore.
Millets.
So you also have to come out with a
what they cannot afford to forget.
So is the state can suggest so we will.
Millets, even the field staff are local. They pretty
Respected Chief Justice, sir,
not that
I am giving you the example. I can show you some photographs. If you allow me, only I want to submit, sir, I want today, because it is not my photograph. All the Bengali leading newspapers, it is reported. You'll be surprised to know the, sir, only sir, my submission, sir.
No,
sir, their SIR process is only for deletion, not for inclusion. Mismatch, not only the title, sir. Mismatch, mismap, unplanned. Now suppose a daughter after marriage, she go to the in-laws house. Now why she's changed her title? Why she is using the husband's name, husband's title? That is also mismatch. Yes, sir, they have done it, sir. Now, sir, only just want to, sir. Number two, sir, there are some daughters who married and shifted the in-laws house. Their number also just unilaterally deleted. It is just because they shifted their houses. Sir, you will appreciate sometimes some people work some office, they go to they transferred other offices, they work somewhere. Sometimes the poor people, they purchase the flats, they shifted their addresses, but they are the genuine people who are staying there. But because of the name of logical discrepancy, now they change the name. No, instead of logical discrepancy, when you gave order, sir, they violated, and they say it is a discrepancy mapping. Sir, can they even violate your order? Number two, sir, we are grateful. Bengal people are so happy that this court gave order that Aadhaar card will be one of the proof documents. But they said no, with Aadhaar card. Sir, in other state, sir, the domicile certificate is allowed. Sir, the family registered card is allowed. Sir, the government housing card is allowed. The health card is allowed. The bank books means whatever caste certificate is allowed. Only they targeted Bengal on the eve of election. Sir, 4 state opposition states are going for on the eve of election. But why? After 24 years, what was the hurry to do it? What it takes 2 years? Only within 3 months, even when the festival season is there, when the harvesting season is there, when people are not in a mood to be in the city, they were in the outside, but they are traveling, and that time they issued the notices and all this. Sir, more than 100 people died, sir. Can you imagine? Sir, BLOs died, and they have written in the letter that CEO is responsible for my committing suicide. So many BLOs are murdered, they died, and also more than 150 people died, and so many are hospitalized. Sir, because of the harassment of the people, because of Bengal is targeted, sir. Sir, you tell me why not Assam? Sir, why not Assam?
The state government, we cried foul, saying that
why not Assam?
Cooperation. They say
why not Northeastern?
Madam has come all the way to speak something.
Indeed, Millet. But the only thing is that, Millet, if it's off the record, we need to.
Madam Mamata, let me clarify 2-3 things to you. About the Aadhaar card, this matter is about SIR's validity issue. SIR's validity issue is being argued before us from last more than 2 months. In the main judgment, which was the first case, we have reserved the judgment. Therefore, we are not in a position to comment with regard to the credibility, credential, or admissibility, and to what extent about the Aadhaar card. That issue has been argued before us. We have reserved the judgment. But you also will appreciate Aadhaar card has also its own limitations when you will read that statute under which it is issued. At the same time, with reference to its insertion in the RP Act, what will be its value? We are yet to determine that part. You have one part. Second, you have pointed out this issue of the discrepancies part. In this case, one way out can be that you give a team of officers, the Election Commission can take them on deputation in the sense that those can also be part of the Election Commission team, verify that here it is a spelling mistake, or it is only because of the local dialect that this mistake is occurring. Those must be rectified. That has to be rectified. So let us see what response they will give. We will grant them 1 day time. Tomorrow or day after.
No, sir. What happens, sir, ultimately, in practical, ERO has no power now. They have superseded all the power from DO, ERO, BLRO. Only they have appointed 8,300 micro observer and the role observer from the BJP rule state, so that DO cannot clear the name. It is all micro observer can delete all the names sitting inside the Election Commission office through AI. Sir, earlier 58 lakhs are being deleted. Even they were not allowed to file Form 6. Sir, earlier first phase, 58 lakhs deleted. There are so many people are alive, and now they are being declared that they are dead. Sir, the anti-women, so many women.
Madam Mamata, if need arises, we will mandate it, we will direct. Every document will have to be signed by the BLO, who are the authorized officers and who are the authorized notified officers.
Kindly see the directions in the website, Millers, so far as the so-called micro observer.
Micro observer is a final authority. Election Commission, WhatsApp Commission. WhatsApp Commission is saying it is only the micro observer. Only they are deleting all the names.
They
are all Government of India officials.
My lord, in one of the matters, government is the party. Lord,
And the problem is that they are not allowing the people.
let the matter.
They are not allowing the officials.
Simply for most of the
They are not allowing the domicile certificate. They are not allowing the government certificate.
Let that be a direction, Millers. We should be served the copies.
May I just highlight?
I have something.
Yeah, I just want to highlight 2 points. If your lordship would just take up, I want to save time, so just go to my note for a moment. Just go back.
No, I want to intervene for 1 minute, if your lordship permits, Lord. We have written several letters to the state government to give us Group B, Lord, the class 2 officers of the rank of SDM or equivalent, so that, Lord, EROs can be appointed. That's the standard pattern, Lord, that they should be class 2 officers because they decide vital rights, papers, and all that.
No, that has.
Now they have given, Lord, only about 80 officers of that rank. Rest, all of them were given who were clerks and below, who are working under the pressure of the state government. Therefore, we had to appoint, Lord, micro observers who can assist, Lord, in case, Lord, they are in the confusion. So the fault lies with them in not giving us class 2 officers for performing the job of AERO and ERO. So that's the reason why this is happening. And these micro observers are validly appointed under Section 13C, read with 3.
No, there is no statutory rules.
My learned friends are not right, Lord, that they are not, we are not entitled to appoint them. If this is the state of affairs, which is not contemplated by the rules and the state is not cooperating, then there's no alternative except to appoint the observers who can assist. Class 3 officers from Anganwadi and so on, they are being given to us. So that's the reason why
there is only one.
But they are not assisting.
There is
They are
one,
taking.
one,
They are taking
one side of the story. Maybe true, may not be true. I'm not going to. There is one more petition where the Election Commission of India has filed an affidavit. So that also may be taken on record. It's not listed on board. It was mentioned by Mr. Giri. Lord, I am appearing in that matter and I have read the affidavit. Lord, that also will have some bearing, my Lord, in ultimately what your lordship passes the order.
And we have highlighted all the difficulties we have been facing, Millets.
My lord, My lord, my lord.
My lord, it is pointed out the
Yeah,
hostility.
just
which
have
is
1
there.
minute. I
My
just
lord,
want
I
to
just want to
highlight.
say victim, that's all, my lord. I'm saying let us confine.
Ultimately, we
No, no.
will ask them to at least 2 days time, we'll have to give
Yes,
them
yes.
to seek their response.
Sir, matter is not correct, sir.
Survey copy minutes.
But fair enough.
Rama
What I'm
Kapil.
highlighting is
There
just
is no
2 things so
problem
that your
of
lordship
time.
sees them.
Let me say this, there's no problem of time, my lord.
The first
Have
point,
some buffers if there is
Arey bhai, eta
more than 1 crore already heard. And if somebody is not heard, your lordships are there and we have, our
Granting,
power is
we
there.
have been extending time, we have been extending time, we have been.
My lords have passed a slew of directions.
My lordship, with my humble regards, may I tell you, sir,
Whatever they have pointed out,
my
and my
opponent lawyers raised,
is that.
sir, sir, that is not correct. That is not correct, sir.
Madam Mamata, we have no doubt about the ability of Mr. Diwan. He is one of the best senior counsel you have chosen.
Yes,
Let him
with his permission.
on your behalf.
With his permission, sir. Only one thing, sir.
Your point we have well taken.
Sir, it depends on some district, some states, sir. We have suppose 44 district. We have 23 district. Now SGM is depends on the district wise. Now whatever we have the strength, we have included all. We are cooperating to them all. Micro.
To provide class 2 group.
Yes, we have given, sir. Whatever they ask, we have given. But they are telling
All right.
what I don't believe.
I think we will be able to find out a practical solution.
Very well.
On Monday, when we take up this matter, we are granting them 2 days time to have instruction based upon all the notes and information which you have gathered.
Very well.
And you also on Monday, please give us the list of the Group B officers which you are in a position to spare and to provide to them for their
Furnish it in
assistance.
advance.
So that
And your lordships may list that matter also because
Yes.
there is direct bearing on that.
I see.
There is an atmosphere of hostility. Election Commission says.
And it contains all our communication to the
but
government,
with written
trying for help.
issued contemporaneous.
issue notice.
Lords, I have one apprehension, that's all I have. I don't want Mr. Dwivedi coming on Monday and saying, now we have finished 1.2 crore hearings as a figment of his
It's all right.
numbers.
We are entitled to our different.
That's what we said.
That's an ongoing exercise that will continue.
Sir, only my last submission, sir. Sir, whatever they have only first phase 58 lakhs deleted. They didn't have any scope to appeal even Form 6. Number 2, the second phase, 1 crore 30 lakhs. Only my request would be, whatever the system is maintaining the other state, they are only targeting Bengal. Only for Bengal, they appointed these micro observers.
Not the forum, millet.
Yes, for to bulldoze the West Bengal people. Sir, my humble submission will be, sir, the logical discrepancy case not to be deleted. And there should be, as it is, it should be cleared by the DO and the ERO, not with the micro observer, not with the roll observers.
Millets, they as well see your lordship's directions at the last occasion.
Give us the list of the officers whom you can spare.
Yes.
Whom you can spare.
Yes.
Probably, once the officers are made available,
Yes.
then micro observer will not be required.
Not be necessary, absolutely.
Yes,
Yes, absolutely.
Whatever the
And on
role they
Monday
are
itself, we are taking up the matter on Monday. Meanwhile, they will also get instructions and you also give us that list.
Very well.
Mr. Diwan, please ask your junior to give complete set of paper book.
Of course.
In both matters, we'll
Both matters. And in Mr. Gopal's matter, very learned in
Sir, or with my humble regards, I convey my great regards and I will extend safe democracy.
Joy
Safe
Goswami
democracy.
is a renowned author, Jnanpith Puruskar awardee. There might be some mistake. Please, you tell your officers also to be a little bit sensitive.
We'll examine, Millets.
Don't issue notice to persons like.
We have never been divorced from common sense. We are addressing them.
Some extra time is required to spend.
So just one last thing I want to flag. When we argue the merits in Bihar, your lordships noticed this logical inconsistency, etc. were not issues there. The problem is every time a new state comes up, there will be a new issue which has absolutely no constitution.
Every day changing the decision.
State may have
Now,
problems as they have been creating.
New issue.
Yes.
Every state will have some new issue.
Exactly.
It is bound to be also.
But it has to have a legal basis. Without a legal basis, they can't start examining something which is not from the draft.
The
at
state
all.
government fights a constitutional body. What could be the legal basis?
Issue notice in both the matter. Issue notice when assisting counsel so and so notice in behalf of the Election Commission of India wants to accept notification on behalf of the three electoral officers West Bengal. Then say we have briefly heard Sir Shri Shyam Devan and Gopal Subramanian, Lan Singh, Mr. Trivedi and Rakesh Trivedi and Mr. Naidu, Lan Senior Counsels representing the Election Commission of India. During the course of hearing, it is pointed out by the Solicitor of India that there is another petition hearing number so, and the issues raised therein or the affidavit filed by Election Commission of India will have some bearing on the merits of these cases. Consequently, that order petition is also ordered to be taken up along with these cases on Monday. Due to date of the Monday, the parties shall have respective instructions on the date fixed.
Great.
We'll take up on Monday.
Grateful.
Thank you.
Sir, we are very grateful, sir.
Grateful, madam.
No, of course, sir. Of course, sir. Please protect the people's rights.